Everyone ready, set, and we are going to start this process. So Janusz, I'm going to bring up your slides, and then we can start. I think for most of you, Janusz doesn't really need an invitation because he's a friend, and he's been in the food industry for so long that I think most of us will know him. But let me do this very good friend of ours justice. Janusz is a partner at Hahn & Hahn, which is a firm of attorneys which deals specifically with food law, as well as intellectual property, trades, patents, those kinds of things. Janusz is not just an attorney, he is also an engineer, which is great because he understands some of the technicalities that we have to deal with in the food industry. And so when it comes to the interpretation of food law, I think Janusz is definitely the sort of best position to be able to assist the food industry. Janusz is and Hahn & Hahn are custodian members of SAFOST. You'll be hearing him speak at the SAFOST workshop on listeriosis. He's even speaking on the second day. He's going to be chatting to us about recalls. So this is a preview, a sneak preview, if you like, of what's coming at the Listeria workshop. So I'm going to now, without any further ado, I'm going to pull up the slides and we're going to start the presentation. Janusz, thank you so much for being with us this afternoon. We really just love having you.
Thanks, Linda.
Okay, Janusz, over to you. We've obviously had so much in the press recently regarding Listeria. The media channels, all media channels, in fact, have been flooded with the disturbing news of this outbreak. And at the end of the day, we wanted to make sure that we all understand the legal implications of this particular outbreak. Today I see that we're specifically going to be talking about the liability. Since our last webinar on the issue, we've obviously had several reports of food establishments being sampled, being visited by the Department of Health. We even had the closure of Sovereign Foods and then the subsequent clearing of Sovereign Foods in the press. This weekend, a fast food outlet, a newspaper report regarding a fast food outlet. And I'm sure there's many food companies that would really like to understand where do they stand legally as far as this issue is concerned. So maybe you can give us a bit of a background with regards to what the law has to say about Listeria.
Sure. No, thanks, Linda. I hope you can hear me. Oh, I see I'm now getting a bit of an echo. Are you getting an echo as well, or is it fine on your side?
No, I'm good on my side, Janusz.
Okay, that's perfect then. So, first of all, I want to say that in the last week or two, I've had quite a number of phone calls because people don't really want to put it in writing, 1 or 2 emails from food companies, but more importantly from laboratories that are saying, we've been sent samples by people in the food industry and we have found Listeria. What are we to do? So I've tried to incorporate that in the talk that I'm going to do today, because obviously that's at the top of people's minds. And it would be very worrying if food companies stopped testing because they were worried what will happen with the results should they be positive for Listeria. So without any further ado, maybe you can jump to the next slide. So let's start off and talk about the Foodstuffs, Cosmetics and Disinfectants Act. And I'm going to first speak about a regulation there under, before I get to what the Act itself actually says. But what's quite important is that R692, which is the regulation governing microbiological standards for foodstuffs and related matters, says that for microbiological specifications, the analysis or examination of a foodstuff referred to in these regulations for determining the presence of bacteria or other microorganisms, and here come keywords, listed in column 1 of Annex A, shall take place in accordance with the method listed opposite thereto in column 2 of said annex. The problem with this is that if one has to looks at those annexes, Listeria is not in there. So, yes. In fact, Listeria does not fall under this regulation where one would expect to find it. And possibly this then becomes part of the problem, because that which people are legally obliged to check for and standards that they're legally obliged to comply to do not include Listeria. Maybe the next slide. So having looked at that regulation, let's actually look more broadly. What does the Foodstuffs Act itself actually say, and what are the consequences of not doing what it says? So in section 2 of the Act, right in the beginning, it says, any person shall be guilty of an offence if he sells or manufactures or imports for sale any foodstuff or cosmetic, and here come the important parts, which is contaminated, impure, or decayed, or is in terms of any regulation deemed to be harmful or injurious to human health, or which contains or has been treated with a contaminated, impure, or decayed substance, etc., etc. It talks about injurious to human health. So although Listeria is not specifically mentioned, this is broad enough to catch Listeria. Because what it tells you here is that if the foodstuff is contaminated, you are in fact committing an offence.
Absolutely.
Yeah, I think you went one slide back. I think
sorry, one back. Sorry, apologies.
Yeah. So, sorry, go to the previous one. There we go. So, if you are not complying with this and you are found guilty of an offence, as it says in the opening line of this clause, there are in fact possibilities of a fine or imprisonment. And depending on how many convictions you've had previously, you could get a sizable fine or imprisonment for up to 24 months. So it's quite serious. You know, you need to take this seriously. Besides it being serious for the public, it's serious consequences for you if you're selling a foodstuff which is contaminated.
Of course, of course.
I'm going to move to the next slide.
Sure.
So under the Foodstuffs Act, in the hygiene regulations, there's this concept of a person in charge of premises. And this is often overlooked. You know, when you look at companies that operate restaurants, retailers, and the like, there's a little certificate up in the corner, and it says COA, and it's issued by the municipality, and somebody's name appears there with an ID number. That person being in charge of the premises, when there is unsound, unwholesome, or contaminated foodstuffs which are sold, can be prosecuted under the Act, and they are the ones who can in fact receive the fine or prison sentence. It's not somebody somewhere far away in some head office.
Yes,
of course, there are certain companies who have taken a view that they put one person's name on all the COAs in all their outlets. I would not want to be that person.
No, no, definitely not.
That person doesn't actually know what's happening in the restaurants, but he could be faced with this prosecution because he is the person in charge of those premises. And if he's not in charge, in other words, he's named, but he's not doing it, in fact, he's reckless. So companies that are doing this should very seriously consider whether this is wise, and maybe the inconvenience of moving people around and then having to reapply for a COA with the relevant person's name on it is in fact not such an inconvenience when all things are considered.
Absolutely. Having said, you know, you said you've had lots of queries from labs in the last couple of weeks. We've had loads of queries from people trying to find out how to get a certificate of acceptability. So yes, I think we still have a problem in that regard, and that we may have many outlets that simply do not have this piece of paper. And so, you know, there's a person who doesn't even understand what the most basic requirements are in terms of legislation. Can we just stay a while on this? I mean, in terms of the person in charge, this person who's in charge, by saying that you're the person in charge would, of course, in no way allow you to claim immunity or ignorance from what these things are about. So in other words, you know, you might be an entrepreneur who has a lot of money and doesn't really understand what Listeria is all about. And if you're found to be the source of this outbreak, ignorance is not really going to assist. You're supposed to be the person in charge and understand the risks associated with food.
No, absolutely. Must be by now 8-9 years ago. I had to defend a criminal prosecution of a store manager of one of the big retailers who was being prosecuted because member of the public had lodged a complaint with the EHPs in the particular municipality that they had bought some meat which they claimed had a maggot in it. In effect, it's a similar type of provision. And
yes.
they prosecuted two people. They prosecuted the person in charge of those premises, and as a second defendant, they prosecuted the person in charge of the entire company's butchery division.
Oh my word.
So, as it was, I managed to get the case dismissed and so on. But the reality is that both of those people were at risk in their personal capacities. They didn't charge the company; they charged the individuals.
Absolutely, and so I think this is really important given this outbreak. You know, we're not just talking to the food safety professionals who may be listening to us today on the webinar. You know, this message needs to get out to whoever's name is on that certificate of acceptability, so that they fully understand that they are personally accountable, you know, for ensuring that these requirements of legislation are in fact met.
Yes, absolutely.
Okay, next slide.
All right. There is a small window open for not being prosecuted, and it goes as follows. It says, no person shall be convicted on a charge of selling or importing any foodstuff in contravention of what we've just discussed, if he can prove, and the key word here is prove, not say or repeat what somebody told him or show a letter that somebody gave him. You need to be able to prove that.
Okay.
He or his employer acquired or imported the article in question under a written warranty complying with the provisions of Section 7 and furnished to the employer. That's a type of warranty which must be issued by someone with an address in South Africa. In other words, somebody here has to be liable. You can't be importing a product from overseas and get a warranty. That warranty won't help you here. So if you imported, let's say, let me not pick on anything, but let's say you imported poultry, and that poultry was the source of the Listeria. You couldn't say, oh, but they gave me a COA and a letter in whichever country. That wouldn't serve in any way to prevent you from being prosecuted. It then says, in addition to having this warranty, at no relevant time would you have had reason to suspect that the article in question was in fact contaminated or in some way prohibited. And then finally, you have to sell it in the condition in which you got it. And at no relevant time would you have reason to suspect that it was in any other condition. So if you're buying a frozen poultry product from overseas and you're defrosting it and then selling it in that manner, already you wouldn't comply with the third point. So although if you follow these steps strictly, you as the person in the business may not be prosecutable, you need to make sure that you have all your paperwork properly prepared and ready, all the warranties in place, that the product that is being sold as you got it, etc. So it's quite important. I mean, there is a way to avoid prosecution personally for something you really didn't know about, couldn't know about, and definitely didn't then in any way aggravate the situation.
Okay, all right. So that's quite a technical part of the law, but it's really important in that respect. Okay, while we're here, I've just had a question from someone saying that what about taste neighborhoods, the home industries, and you know, people supplying or baking for them? What about people who are selling food at these farmers markets? And are those small micro businesses also expected to comply with the certificate of acceptability? And I'm going back one step.
Well, there's no specific exclusion for them.
The only exclusion that I know of is possibly a church fete, where it's not being sold for any gain, so to speak.
Sure, but I was phoned once during the 94.7 FM cycle race, where in one of the municipalities which the cyclists were passing through, one of the retailers had put up a tent and I'm not sure if they were giving away food or they were selling food, and they were closed down. And they wanted to know, what must they do? Because surely they're just giving food to the participants and they're the main sponsor. And no, you need a COA.
COA, yes, absolutely.
That's how that is. Wall and start serving food.
Absolutely, and I think we've had to write sort of several articles on this, because it's actually two aspects that are considered. When you decide to park your caravan and start selling boerewors rolls, the COA is only one aspect, but you actually have to have a permit to actually park on public property, and that's a different piece of paper that has to come from a different. It actually comes from the traffic department, and so both of those have to be taken into account.
Okay, there's a question from Terran which says, does this slide mean that once the poultry has been cooked, that it becomes a responsibility of the people who cook it? And the answer is yes, because you would have changed the condition in which you imported a raw or a frozen product, and now you've cooked it. So you wouldn't be able to escape conviction because of point 3 on the slide.
Absolutely. But I think what is important, Terran, is the context of this slide, and please correct me if I'm wrong, Janusz, the context of this slide it's really focused at people that are selling or importing food. So these are the people that are actually in the business of food. We couldn't apply this particular point to the consumer of food.
No, not at all. No.
Okay, so this is to do with the business. Anyone in the business of actually providing it. But if I've imported chicken, defrosted it, cooked it, and it was then found to still be a source of listeriosis, what you're saying is that you've changed the condition, so therefore you are liable.
That's it.
Okay. Right, so what about these inspections that are taking place? Because now everyone is in an uproar at the fact that we've got environmental health practitioners inspecting facilities and taking food samples.
Sure. So first of all, in December, I suddenly saw in the press that there was this raid, or whatever you want to call it, at the abattoir in Pretoria West, and I thought, what is going on here? The news article didn't make any sense initially. They were talking about the Department of Health. And we first need to understand that the hygiene regulations under the Foodstuffs Act are not enforced by the Department of Health.
Yes.
They are enforced by the environmental health practitioner, the EHP, in the municipality where the business is located.
That's right.
The Department of Health is not the enforcer of this regulation. So, in the case of, for example, the abattoir, they went under regulation R962, the hygiene regulations, and these are quite clear. They say if an inspector following an inspection of food premises or a facility, so number one, the inspector has to physically go to the facility. They can't buy a packet of, say, chicken at a supermarket and close the abattoir.
Okay.
To close the abattoir, they have to physically inspect the abattoir. It says inspection of food premises or facility. It doesn't say inspection of the food.
Yes.
And then they are of the opinion that such circumstances exist with regard to the food premises or facility or any other activity, that they or it constitute a health hazard, and that the continued use of the food premises or facility or the activity should be prohibited. So they visit a place, they've now inspected it, they've taken the swabs, they've got the lab result back, or at least an indication of a lab result, and they say, in their opinion, this poses a health risk.
Yes.
Then they are able to prohibit summarily, which means they can say immediately close shop for the use of the food premises or facility for the handling of food or any other activities that relate to the handling of food. And they do this by handing that person in charge, they hand him a written order. They say, we have our order, the facility is closed, and in there they have to specify certain things. For example, if you follow the following cleaning steps, or once you've cleaned it and you get a clear analysis or whatever, you will be able to reopen. So it's not just closed and there's no recourse. They close it, but they give you the steps you need to follow to be able to reopen.
So based on the outbreak that we're having...
But very importantly, that's the EHP, that's the environmental health practitioner in the municipality.
Absolutely, absolutely. So given the current outbreak, there would presumably be some communication between the National Institute of Communicable Disease that is receiving the results of testing on food samples. These results are being made available by food companies, and they've been requesting this information. And if they are then suspecting that there's any problems, or by interviewing patients have then disclosed that they've eaten chicken, for example, that has then sent the environmental health practitioner on an investigation to try and locate the source of the problem.
Sure. Look, the environmental health practitioner can enter upon any premises at any time to conduct an inspection.
Absolutely.
But obviously, in this instance, they are directed through, as you say, the NICD or Department of Health or someone else who says, I think there's a problem at those premises.
There we go.
And then they can go and do the inspection. And there's nothing you can do to prevent them. You have to comply. Trying to obstruct them will land you up in even more hot water.
Absolutely. And as far as I understand, there is also an anonymous tip-off line where if there are, if there's somebody who feels that there is a problem at a specific outlet, there is this line where people are actually able to report these things, which is obviously then taken up by the environmental health practitioner. I think what's just been interesting is people are so surprised that this is happening, but my question is, isn't this supposed to be happening all the time, just as a routine exercise?
Sure, but I think one must also understand that the EHP cannot go and test for every possible thing that could go wrong in every premises.
Of course,
So they have a program, I suppose, they follow. They go and look at swabs, they'll go and look at historical results and so on. As we know, even with the current routine that they're doing of the testing for Listeria, it's a problem. It's causing a huge backlog already. I mean, if they were doing this all the time for everything, I mean, the system would just grind to a halt.
Absolutely. And I think that also points to some problems with capacity that we do have, which hopefully this outbreak will address. But I think, if we were just to think about it with some common sense, it would be ideal if each municipality at least had an understanding of the companies that do operate within its jurisdiction, and there's some sort of risk rating, and higher risk premises should therefore be inspected, on a more regular basis. I think that's probably how it happens in the rest of the world.
I would presume so. I mean, in this particular instance, obviously it's reactionary.
Yes, of course.
But I presume clever people have sat down and said, look, the likely sources of this are the following, A, B, C. So they're not going to inspect things which are highly unlikely to be the source and are starting with those that are the highest risk and moving down the chain until they find the source.
Yes, well, one would hope so. Okay, so the powers of the inspector, you made the point that we cannot refuse them access.
Sure, but I think it's important to understand that the powers of the inspectors are actually in a regulation. I have in the past come across some inspectors who have not understood where their powers start and end. And I also got to admit that some of my clients don't understand where the inspectors' powers start and end. And in fact, the inspectors have quite far-reaching powers in the interests of the health and safety of the public. And a lot of things are left up to their opinion. There's no specific prescribed limits. And that's why I put this particular clause in here so people can understand that it says, if an inspector is of the opinion that in relation to food premises or foodstuffs contemplated in the Act, activities or conditions exist which are dangerous or harmful, or likely to be dangerous or harmful to health, or which they are likely to favor the spread or impede the prevention of a foodborne disease, for example, the Listeria outbreak now, he or she shall issue a written order in a format provided in Annexure F, signed by him or her and addressed to the person in charge, in which he or she instructs that that particular activity must stop, or be rectified immediately or within a specific period of time, etc. So it comes down to what the inspector's opinion is at that point. And unfortunately, as you'll imagine, in a scenario we have now where there's this large number of deaths and illnesses, the opinion might be tainted by that. And in fact, they might take a decision which they otherwise would not have taken to close a facility. And of course, one then has to say, is it better to err on the side of closing a facility which may not be the source, or allow a facility which may be the source to continue to trade? But it comes down to that EHP. They are the ones that decide.
Sure. Okay, so in terms of Well, first of all, I know with regards to other pieces of legislation such as the Competitions Commission or the Competitions Act, there is the need for a company to be prepared for what we would call a dawn raid. If there was to be a sort of a sudden inspection of your facility that is unannounced. I think it would probably be prudent for a company to actually sit down and to have a protocol for dealing with the EHP, for dealing with, I suppose even inspectors from the Department of Agriculture, because I think you want this process to, as you said, happen without any perceived obstruction. But I think it is also important that we have, some sort of procedure in place that we know what to do if this does happen.
Oh, absolutely. I mean, you get, I'm sure we all cringe when we think of that ETV program of when the EHPs arrived at that facility in Bloemfontein and the manager ran around and ordered his staff to shut the doors and not let them in. Because he had to first phone head office and find out from his boss if he can let them in. So clearly there was an unprepared employee. He had no idea what he's supposed to do. And apparently the person he phoned also didn't know. But anyway, that's a different day, that's a different story. But yes, one should be prepared for these things. But it's also in terms of the Consumer Protection Act, because the way the Consumer Protection Act is written is very similar to the Competition Act. So there are also provisions that the National Consumer Commission could conduct a raid on a company. Let's say under the following circumstances. Some people have now died and now they find the source. And now they want to know, but was this just complete, they just didn't know they were the source, or were they trying to cover it up? Were they ignoring it? How long did they know? So in the interest of protecting the public, the National Consumer Commission could arrive with a warrant and do a raid and then start looking through laboratory documents, going through board meetings, management meetings, and should they find documentation from which it's apparent that the company knew, but let's say in the interest of profit, decided not to do anything, but let's just give it another good clean and hope it goes away type of thing, there could be very, very serious consequences. The Consumer Protection Act, I think I speak about it a slide or two later, have some very big fines they can apply, which are up to 10% of turnover of a company. But there's also even provision for criminal prosecution in some circumstances.
Yes, absolutely. So I think what you're saying is really important in the sense that, sure, we've got the food sample is one thing, but it's not just the food sample. There's other evidence that could also incriminate a company in not dealing in the correct way as far as public health is concerned, and in not correctly managing a risk which could be injurious to human health. And so therefore I think what you're saying is that our food safety management systems at the end of the day are supposed to be providing us with all of these aspects to ensure that our efforts are focused to ensure public health is protected. And so that's exactly what we should be doing at every level within the business.
So let me just say this, that the slides up to this point, excluding this slide, really dealt with criminal issues. These are the laws. If you don't do it, it's a criminal offense. From the slides that I'm following now deal with a claim, a consumer who got sick, or the relatives of someone who died, the claim they might have. So let's just talk briefly about the criminal provisions. It's not an excuse to say you didn't know. A number of years ago, there was a court case that went all the way to the Supreme Court about a bee in a bottle of soft drink. And the court set a very, very high mark there when they said that it's not sufficient to say, oh, but we tried our bestest. Sometimes bees just get into a bottle. And the company was in fact found guilty of contravening the regulations by having, in fact, they contravened the bylaws of the city of Durban, but it's very, very similar to the hygiene regulations in that there was a foreign object, i.e. a bee in the soft drink. So you really do have to do your best. It's insufficient to say, oh, well, we can't afford better equipment. Oh, well, we can't afford testing. Oh, well, whatever the excuse is. The law won't see it that way.
No.
It's a strict requirement. You may not operate a place that poses a health hazard, and if you're unable to do so, then you shouldn't be trading.
Absolutely.
It doesn't say you must do it as best you can afford to. It doesn't say that.
Yeah, no, absolutely. And I think although, the best available method may be a definition that is provided in the hygiene regulation, I think even that is important to take into consideration when you are looking at a multinational corporate as opposed to a street vendor. Can you demonstrate that you've done everything that you should be able to do given the fact that you have, the resources are available? Okay, we've got a couple of questions, Janusz. First one from Madeleine. Hi, Madeleine. If a facility is issued with a directive and it's corrected. Sorry. So in the case we've had, directives were issued and the abattoir took the appropriate corrective action, and that directive was closed out. Does it work on a cumulative basis? So in other words, you get strike 1, strike 2, or is each case does each case stand on its own?
My understanding is that if it poses a health hazard, it's a case until it no longer poses a health hazard.
Okay.
It's not a cumulative thing because the health hazards could be different.
Sure.
You could have currently a Listeria health hazard, and the next one could be something completely unrelated. It's not like labor law where you have to get 3 written warnings in 6 months or anything like that.
Okay.
If you currently pose a health hazard, you could be closed right now.
Absolutely. What about other facilities that are not necessarily selling food but are serving food? So Renelle has a question with regards to jails, hospitals, clinics. I even had a question this week regarding old age homes, preschools. Are the environmental health practitioners, are they also required to inspect those kind of government facilities?
To be honest, I can't think of seeing an exclusion anywhere.
Yeah.
The only way they would be excluded is if they weren't. I think that I don't have a copy of the hygiene regulations in front of me, but I think it talks about premises. Is it not where food is prepared? I think preparation of food is also included in the hygiene regulations.
Yes, yeah,
which would then mean that. Sorry.
No, carry on.
So if it's covered in the hygiene regulations that way, then if food is being prepared, it should comply with the regulations. I presume you're not selling food to prisoners.
Interrupted you. Continue. To have a technical.
Sorry.
Are you back, Janusz? Sorry, we lost you for a moment. Would you mind repeating yourself?
Sorry.
We lost you for
I'm
a minute.
saying that as long as the activities are what is stated in the hygiene regulations, and I think one of them is preparation of food and handling of food. I think the term is actually handling. So all of those facilities would handle food, and there's no exclusion in the regulations or the act of any government facilities that I'm aware of.
Of course. Okay, now when it comes to strict liability, let's talk now about the liability aspects. You've been talking about the criminal requirements or sort of criminal implications. If we're now thinking of those consumers, and we have to bear in mind that given the statistics that are available, a large number of consumers have been affected by this particular outbreak. Unfortunately, we now hold the record for the highest number of deaths in any one listeriosis outbreak worldwide. What are the implications for companies that could be affected and consumers who want to now, take action?
So the Consumer Protection Act really. This could be a big test for how effective the Consumer Protection Act is. For the following reasons, is that the Consumer Protection Act brought in this concept of so-called strict liability. So strict liability no longer requires an importer, producer, distributor, retailer, etc., to have been in any way negligent. The mere fact that you are the source of the Listeria that made somebody ill, you would be liable. There's no longer this test of, but could you have foreseen what was going to happen? Did you do the best you could? That falls away now in terms of the liability for any harm and it's quite interesting. It talks about harm caused wholly or partly as a consequence of. And it says supplying any unsafe goods, a product defect or hazard in any goods. The inadequate instructions one I found quite interesting. I read it and I thought to myself, of course, if you've got proper cooking instructions, and we all know that cooking would prevent you getting ill from Listeria, then that could, to some extent, remove the risk of the liability. Because if let's say the Listeria was in chicken, and it was in raw chicken, and the instructions say, do not eat unless properly cooked, or and the person undercooks it and they get ill, then they would have been contrary to your adequate instructions. So the importance of proper cooking instructions now become even more important. And then
absolutely, and I think, sorry, Janusz, also storage instructions, you know, making sure that the cold chain is properly maintained, make sure your fridge is actually cold enough. And I think also the best before dates, you know, sort of any warning with regards to the date and how long you should keep this product before, you know, you finally, you know, no longer consume it. I think as we've seen and learned about this particular organism, you know, these factors are very important, and you know, producers of food should be re-looking at their labels, I think, at this point.
And if you look at number 2 on my slide, it talks about a supplier of services who, in conjunction with the performance of those services, applies, supplies, installs, or provides access to any goods, must be regarded as a supplier of those goods to the consumer. So restaurants, caterers, all of those types of bodies, by the way, including to Ronald's question about the hospitals and all of that, they cannot turn around and say, oh, but we merely took the food product that was supplied to us, we cooked it and served it, or for that matter of fact, we just served it. Because in terms of you would be civilly liable. In other words, you would be part of the claim for the support of the children of the person who died.
Absolutely, absolutely. And again, I think a very sobering paragraph for people who are involved in that process. Just because it wasn't the product that you actually manufactured, but you were in some way involved in the delivery of that product. I think, you know, we all have to take stock. This is not just pointing fingers at certain manufacturers only. Rochelle has a question. She wants to understand, why was the abattoir investigated then? If they deal with raw meat and raw chicken that is going to be cooked, why were they the focus of the food sampling and the whole, you know, sort of furore that went on in the newspaper?
I think we must separate the furore in the newspaper with the legality and reasonableness of going to check the abattoir. They're perfectly entitled to check the abattoir. If it appeared that there might be some connection to this outbreak, they should have done it. The furore in the press is a whole different ballgame. I agree with you. People who didn't understand that when you cook food, it kills the bacteria, etc. That wrote many stories in the press. But in terms of the application of the hygiene regulations, remember, it's about the premises, not about what's going to happen to the foodstuff later.
Absolutely, and as I understood the press release as well as the media briefing, there were in fact 2 departments that were involved. So the Department of Agriculture, who actually would have jurisdiction over the abattoir in terms of the Meat Safety Act, had previously done inspections, and there were some issues that were already being dealt with. As far as I could understand from the sort of chain of custody of the evidence, the patient had been interviewed, samples had been taken from the patient's home, and the source of the chicken had been identified as a particular retail outlet, and the supplier to that retail outlet was then part of that inspection. So what the environmental health practitioner was doing in terms of the regulations, the hygiene regulation, as well as the information that they had obtained, because the patient was in fact one of the sufferers of listeriosis. So I think they were just doing, you know, so they were doing sort of a backwards audit, or they were tracing backwards, which is why they then, you know, landed up at the abattoir. But there were, in fact, if you go and read please go and read carefully the media briefing, the media statement that was issued, because in fact the Department of Agriculture were also involved in that particular situation, but for an unrelated matter. And I think it's important to be very clear as to, you know, the facts around the case, which I think are better understood from the press release that was issued by the government. Okay, let's move on then, Janusz, to continue with the Consumer Protection Act and continuing with the liability that is, you know, associated with, you know, the
so
consumer.
Point number 3 simply says that the whole supply chain is liable. If the whole supply chain is liable, they're all equally liable. The supply chain, the retailer can't turn around and blame the abattoir, or turn around and blame the importer. I, as a consumer who buy the end product and there's Listeria in it, I would be able to hold everyone in the supply chain liable unless number 4 applies. So number 4 applies. Number 4 says that liability of a particular person in terms of this section does not arise if the alleged unsafe product characteristic did not exist in the goods at the time it was supplied by that person to another person alleged to be liable. So what it's saying there is, in fact, I sold it uncontaminated, it went to the retailer, they contaminated it. Then the supplier can't be liable. That's what that says. She says, sorry, yes?
No, and I think again, the importance for systems at that handover point, at each step in the food chain, to make sure that, you know, both parties are adequately covered to ensure that this kind of situation cannot arise, or this particular clause in the legislation is there not?
Sure, because of course, if I'm the wholesaler, let's call it, or the manufacturer, producer is a better term, and now I want to rely on this clause, I would have to show that when I sent it to you, there was nothing wrong with it. I cannot simply say it, I'd have to show it, which means I would need to have laboratory results, I'd need to have all this information available to show that it could, when it left my hands, it was fine. Since it's now infected, or it must be on your end. Then the next defense is, it is unreasonable to expect the distributor or retailer to have discovered the unsafe product characteristic, failure, defect, or hazard, having regard to that person's role in marketing the goods to consumers. This clause is a very interesting clause, because I think this clause discriminates against big manufacturers and helps small guys. You know, if you're a mom and pop store that cooks 8 chickens a day, you are unlikely, it would be unreasonable to expect you to be sending samples away to laboratories. But if you're selling 500 chickens a day, you probably should be doing a lot more. And if you're a DC, you definitely should be doing something. So this one looks at the reasonableness of the expectation, to expect the person to actually be checking to see that the product is safe before they sell it. To what extent can they check it? Does it look like it's been defrosted and refrozen? It's arriving and it's at 10 degrees Celsius, not at the desired temperature. So there are all these things you can do without any laboratory.
Absolutely, and I think, again, coming back to the point that you should be doing as much as you possibly can, given where you are and given the resources that are available. Renal has a question. I think the answer is yes, but in terms of this particular slide, Janusz, does it mean that the food outlet, and I'm assuming now that we possibly are referring to a quick service restaurant, that a food outlet could not be held liable for takeaway food, could not alone be held liable for takeaway food? That's the one aspect. But if my thinking tells me, based on what you've said, is that if there's a number of suppliers and I happen to be the final outlet and I'm getting my chicken from this particular quick service restaurant, even within that process, there are a number of suppliers or number of links in that chain, and so each of those could be liable. The other thing is, and I think it links now to the labeling of product. What about a food that is supposed to be if it is a quick service restaurant, for the most part, we're talking about takeaway food. Where would the liability end with regards to a takeaway? Because when I gave it to you, it was in good condition, but the purpose of this food is now to be taken away. Where would liability end in that regard?
Takeaway foods are always difficult because you never know how the person has handled it once they've left your store. But obviously there are patterns. If 30, 40 people that have bought food from you all get sick, it's highly unlikely that they all mishandled the food and you did nothing wrong. So when we'll have to look at epidemiology, you'll have to look at different things. You'll have to look at DNA typing. What in an extreme case. In the case of Listeria, of course, it's very difficult because of the incubation period of 21 to 70 days or something, or average of 21 days, but up to 70. The person who gets sick can't even remember which day they had the takeaway on. So, or maybe they won't even remember that they had the takeaway. So it would be very difficult, I think, to link Listeria to a particular meal someone ate, unless you're really lucky. Maybe they're on a 40-day fast and they only ate one thing, because it will be, I think it'll be pretty difficult. Not different from salmonella.
But I don't think it's, of course, yes. But I don't think we can say that a food outlet would not be held liable for takeaway food. If it can be proven that the food that from that outlet was what caused a number of people to get sick, they would be liable.
Yeah, no, I think so. I think you can definitely, you'd have to prove it or show the link, but sure, it would be liable.
Yes. Absolutely. And I mean, if you just take some of the outbreaks overseas, again, not the same organism, but, if we just think about Jack in the Box, in that particular instance, it was most definitely an outlet. So I don't think we should, I think we might have said that this kind of situation would never happen to South Africa. It has now happened to South Africa. And so I think we need to be careful in saying that, it couldn't happen to a quick service restaurant, from that perspective. Okay, let's move along because we're running out of time. This is really, really interesting. Okay, so harm, I think if you look at this slide, we can no longer say that we have not been responsible for the death of any natural person.
So what this slide says is that, what would you be liable for? So if you are found to be the source of this Listeria, and we know now how many people have died, how many people were ill, etc. So you can be held liable under the Consumer Protection Act for the death of any person, illness of any person, loss of physical damage to any property, etc. That wouldn't be relevant here. D is very important. Any economic loss that results from harm contemplated in A, B, and C. So a father dies, now he has 3 children. Someone has to look after them. Economic loss. Someone was very ill, got meningitis, got, some permanent damage. These claims could be as big as which you get from traffic accidents, when people are killed or maimed, etc. And some of those claims can run into tens of millions. And the reason being is, and I used to always say this in my presentations, you can't pick your victim. So the person who died could have been a brain surgeon, or he could have been the leading stockbroker. So in determining the damages, a court would look, what was this person's income? What was the family's lifestyle before this person died? You need to put them back in that same position. It could be very big sums of money. And that's where I get to this last big red writing, which talks about possible class action lawsuits. So class actions are very, very uncommon in South Africa. In short, what a class action is, every person doesn't need to sue their supplier themselves. A person acts on behalf of all of the parties who are harmed together. The closest thing we've got to this are the asbestosis cases, where there was a big court case made for all the miners that suffered lung damage due from asbestos. They didn't have to individually sue the mines. A big case was made on behalf of all of them, and once the money comes into the pool, it pays for their health treatment, it pays them out money, it does all of that from that pool. Now, if you look at that asbestosis case, that pool runs into 8 or 10 billion rand, for example. Because obviously there's a lot of people that were harmed. We're talking at the moment of hundreds of people who are ill and many tens that have died. So this would be a possibility of a class action lawsuit.
And in this case, the evidence that we already have shows that, sort of more than 90% of the cases are linked to one strain of Listeria monocytogenes. We have this ST6, we have this information. And so, the probability that if the source is found, this kind of action could take place. We've already got half the puzzle.
Okay, let's talk lastly about notifiable medical conditions, because this is very confusing to many people. So the minister announced Listeria is now listeriosis is now a notifiable disease. And this is what led to the laboratories phoning me. They said, oh my goodness, we've now analyzed samples, we've found traces of Listeria. Do we now have to report it? But we've got confidentiality agreements with our customers. The retailer or the supplier that sent us the sample doesn't want us to report it anywhere. What do we do? And you need to understand, this is a different law. This is not the Foodstuffs Act anymore. This is the Health Act. And under the Health Act, it only applies to medical institutions, doctors, nurses, pathologists, and the like, when they diagnose a patient with a medical condition. So when a patient presents and is diagnosed with Listeria, those people must report it in accordance with the notification procedures. Swabbing a surface or checking a drain does not result in anything notifiable under the Health Act. And therefore, there is no obligation to report a swab result unless it comes from a patient, obviously. But of course, one has to balance that against the risk of people dying, getting ill, etc. So you may not want to report it, but what would happen if you don't? And that's, of course, a different issue.
Absolutely. And I think that's really why all the communication that there has been from the Departments of Health, even today, if you go onto the National Institute of Communicable Diseases website, you will see that they are requesting information. So they're asking the food industry to do the responsible thing and to share the information in order to identify the source, in order to prevent any further loss of life. And as we discussed previously, this obviously links to some anonymity. They have said that they will treat this information with in confidence, because at the end of the day, I think it's almost more important right now to just try and stop the loss of life.
No, sure.
Okay, we have one last question, and it's a question that I also wanted to ask you. Taryn is wanting to know, could we as manufacturers ask suppliers of our raw materials for their micro or Listeria test results? The question I had was quite similar in that, do you foresee that there will be changes in contracts between suppliers and retailers in relation to this kind of testing?
Look, I think you're one step ahead there when your question is actually the answer. But I think if you look at most of the supply agreements already in place, they would actually allow for this anyway, because it's such a high risk. So it's likely that they would allow, but it's not written into law. That would be contractually between yourself and your supplier. Of course, your choice is, if you don't give it to me, I'll find another supplier. If I go buy a car and the person won't give me the manual, well, then I'll just say I'll go to another dealer. And that's what you're faced with.
Of course. And I think also we need to appreciate that there are costs associated with this, and it's not that I'm trying to be difficult, but I think in some cases, the conditions of contract also include the price, and if you're changing the conditions of contract, then we would possibly need to to review the price. I had one query from a company where their product is a low risk ingredient in comparison to others that we've been chatting about, and they were asked to give their supplier a guarantee guarantee that this particular raw material did not contain Listeria. And I was a little uncomfortable in that regard, because I think, you should do the test. So rather test every batch and give them a certificate to show that you've tested the batch. I think, in the absence of information, you would need to test. You can't just give a guarantee, sort of across the board. That would not put you in a good place.
It's a similar thing that you find in many contracts regarding GMO. Company will say they want you to guarantee that there are no GMOs in your, because they maybe sell a GMO-free product. And unless you've tested it, how can you give a GMO-free guarantee?
Absolutely. Okay, one last question. Sorry, guys, we'll have to continue this one at the SAFOS conference and the Food Focus workshop. So just to 100% confirmation, does this mean that there is no obligation to report a positive result from a food sample, whether this is cooked or ready to eat? So I'm assuming from the question that this means there's no obligation to report to the National Institute of Communicable Diseases.
Yes, I think maybe just switch to the next slide, because there is one exception you've got to be careful of.
Sure.
So we'll just see. Yes. Okay, this is the one. So the answer is there's no obligation to report it to NICD or an EHP or Department of Health, but, and there's a big but with a big B. Under the Consumer Protection Act, if your product poses a hazard, you have to do a recall and you have to notify the National Consumer Commission. So it's this completely shotgun thing we have here. We've got the NICD, the EHPs, agriculture, but all these different people. Into the mix come the National Consumer Commission under the Consumer Protection Act and the recall provisions under that law. And those recall provisions say, if a product is unsafe, poses a hazard, you need to do a recall. And in doing the recall, you need to notify the National Consumer Commission. So there is your answer.
Yeah, and I think, I think I'm quite surprised that we haven't seen more recalls, because specifically in relation to Listeria, because I'm sure that there are other issues out there, and as you're saying, it would be the responsible thing to do to implement a recall. What if I was what if I'm not in a position to actually do that? I mean, I suppose, when we talk about a recall, we're now going to the press and we're asking people to bring back, food that they may have in their fridges. But what if it was something like a fast food outlet where, I ate it on my way home? Or what then? What then? Because unfortunately, the problem is that the test can take some time before you actually get the results. So if I find a positive sample, but I've already used that product, what?
No, well, then of course there's nothing to recall. I mean, you only recall if the particular product you're still holding poses a health hazard or is unsafe. The fact that a previous product, which already by now is eaten, poses a health risk or is unsafe is a different issue. But if you're a retailer and you're selling frozen products, that of course will again be a very different situation, because the current stock you're getting in may be safe, but you need to recall the batches that relate to that stock on which the particular bad strain was found and identified.
Absolutely, absolutely. Okay, and then finally, I see that you've got a comment with regards to insurance. That it's even with all the best controls in the world, it would be good corporate governance to have product liability insurance in place.
Oh, absolutely, and you've got to make sure that your insurance your liability insurance covers this type of liability. It's not just public liability.
Absolutely.
You've got to read the wording. You've got to get advice from someone who understands the wording of insurance to make sure it covers these situations.
Yeah.
It's not a trip and fall policy. It's actually a policy dealing with this type of situation. Including recall,
it's
because
a product,
recall can break you.
Yes, absolutely. And I think there's insurance for both. You could look at insurance for covering you in the recall situation as well as product liability, but you're quite right. It's not a public liability policy. This is not automatically covered. It's specialist liability cover that you would need to engage with. Okay, everyone, I'm a little worried that our webinar is going to cut off because we had the studio booked for an hour. So if we do lose you, we would just like to say thank you very much for spending time with us this afternoon. Janusz, again, thank you so much for being with us. Thank you for always being so generous with your time. Everybody, please remember that you can, Janusz will be speaking again in even more detail, dealing with some specific issues, different issues at the SAFOS workshop on the 14th of February and at our Food Focus workshop on the 15th of February. Please note these are two different presentations, two different agendas, so they're designed to be back-to-back to give you double the value. So I'm going to just take one last question, if you don't mind, Janusz, from Rajan. Just a comment, anything injurious, if in dealing with the Department of Health, any injurious to human health, whether ingredient or micro, must be reported to the authorities. No, I don't think that's what you said. I think it's in terms of the Foodstuffs Act, you are required to we're required to make sure that foodstuff does not contain anything that's injurious to human health. Am I correct?
Yeah, no, there's nothing. The Department of Health sometimes makes statements like this, but where in the law does it say it? And quite frankly, if that was a situation, they wouldn't be asking people to voluntarily and guaranteeing confidentiality, be asking for people to report results. You know what I'm saying? If it was an obligation, they would say, look, you've got a legal obligation, report it or else.
Yes.
The fact is they're asking people voluntarily to submit the information and guaranteeing supposedly confidentiality.
Absolutely. And so, again, as I think we've discussed, the right thing to do is to rather share the information at this point in time. We all want to get to the bottom of this, and it's the ethical thing to do. Janusz, thank you so much. Everybody, thanks so much for joining us. Thanks for your questions and your comments. And we look forward to meeting you at our workshops in February. Janusz, thank you so much. Over and out, people. Over and out.